Hello, good evening, everyone. Welcome. My name is Marina Pavlovich. I'm a professor here at the Faculty of Common Law. I am also one of the interveners in this case on behalf of CIPIC, Canadian Internet Policy and Public Interest Clinic. I am delighted to welcome the audience here and numerous counsel in this case. It's been a long day, but we hope we're going to have a little bit more fun today talking about the case. I would like to introduce Vivek Krishnamurthy, who is the newly appointed director of CIPIC, who will act as a moderator for the panel, wearing his moderator hat, not necessarily the client hat. And some people will have to leave a bit earlier to catch their modes of transportation to wherever they need to get. So there may be comings in and sort of people may come in and leave at some point. We're still waiting for a couple of lawyers to join, so it will be fairly freestyle, I think. So, Vivek, over to you.
Thank you, Marina, for that introduction. Thank you to all of our distinguished counsel who appeared before the Supreme Court today for taking the time to join us today and provide your insights on what I think was a really interesting and active hearing in Uber and Heller today. This was a court that I felt was extremely engaged in this case in a way that you don't usually see in an ordinary, contractual case. And I think it speaks to the importance of the issues that the case raises in terms of thinking about the future of the platform economy, the gig economy, what it means to have these standard form contracts that govern so much of our lives. So really significant issues, and as Marina said, CIPIC, which I direct, was an intervener today, ably represented by Marina. I am taking off my CIPIC hat, putting on my professor of law hat, to be an impartial moderator of what I hope will be a discussion as to what happened today and what some of the stakes are in this case. So we're waiting for one more person to join our panel, counsel for Heller. But I thought we could just begin with a round of introductions down the line. So you could just tell us who you are and who you were acting for today.
So I'm Matthew Milne-Smith of Davies Ward. I wanted to acknowledge that my partners Chantal Shea and David Ionis, one of our articling students, are here with me as well, and they played an integral role in obviously preparing the factum and preparing for the hearing. So we acted for the Canadian Chamber of Commerce.
I'm Craig Chason from Ford Manager Bay in Vancouver. Myself and my colleague Rob Dean out of the Vancouver office and Hugh Meehan out of Toronto were acting for Arbitration Clause. Rob did the submissions and the others of us worked on the paper.
My name is James Plotkin. I, together with Alyssa Tompkins, acted for the Canadian American Bar Association, whose views should not be, or my views should not be imputed onto theirs for anything I say.
Goes for all of us.
Yeah.
My name is John Sewick. I'm a lawyer at Purley Robertson, which is a law firm here in Ottawa, and I was on for the Young Canadian Arbitration Practitioners, and we were co-counsel with Eric Morgan at Ozers in Toronto, but Eric couldn't be here today, unfortunately.
I'm Alexandra Monkhouse, and together with Andrew Monkhouse, we acted for Don Valley Community Legal Services, which is a legal aid clinic that represents low and middle income workers.
And I'm David Stearns with Sotos LLP in Toronto. I was here to keep a seat warm while my associate Mohsen Sadiq made the arguments and presented his thinking to the court on behalf of the Consumer Council of Canada.
And my name's Anthony Damesis. I'm a professor here at the faculty. I was on for the Canadian Federation of Independent Business, Canada's largest non-profit organization that is really devoted to helping small and medium-sized businesses. And I was helped with Anna Kadick, who kept me, I would say, for my first draft of the factum, helped me to get rid of all the ad hominem attacks against lower courts' specious reasonings.
My name is John No. I'm a lawyer, Workers' Rights Division lawyer at Parkdale Community Legal Services. We intervened in coalition with the Income Security Advocacy Center. My colleague Nabila Qureshi did the oral submissions.
My name is Wes McMillan. I am a lawyer at Allen McMillan Litigation Counsel in Vancouver, so no reason for anyone here to have heard of it. Me and my partner Greg Allen intervened on behalf of the Community Legal Assistance Society of British
Hello everyone, I'm Marina Pavlovich. As I said, I'm a professor here. I represented CIPIC, and I was really the face of an unbelievably capable team, including Johan Kwan, who was called to the bar 3 weeks ago and gowned and sat with me, which was amazing. And then Christian, and Sanjit, I don't see them here, who are interns at CIPIC who did a great job. So I really wanted to acknowledge that it was really the team that was there, except that I had to sort of be the face of it.
I should add that I'm a UO grad, so expect good things in the future.
And I'm Andrew Little. I'm a partner at Bennett Jones in Toronto. My colleagues and I intervened in this matter for ADR Chambers, as we did in the Wellman case last year.
So to kick us off, I was hoping we'd have the counsel for Heller kick us off here with an explanation of what initiated this case. But we're going to just press on regardless. So maybe I'll call upon my Ottawa colleagues wearing their professorial hats, please. Just could you, maybe Anthony, could you just give us a quick summary of what this case is all about? Because I know you all did the reading. You all read 17 Facta and all the decisions.
Heller's here.
Pardon me? Oh, here they are. Here they are.
So I won't poison the well. We'll let them.
Yes. Okay, so if our new guests could introduce themselves, we were just about to start the substantive part of the afternoon. So Michael, yes, you tell us a bit about yourself and yes.
Michael Wright, I'm a lawyer. Along with my colleagues who will introduce themselves, we acted for Mr. Heller before the court today.
So I'm Danielle Stampley. I'm Michael's colleagues. We're at Wright Henry, relatively new firm as of August. And yeah, I think we focus primarily on labor and employment cases, but we do some class actions.
I'm Lior Samfiru with Samfiru Tumarkin LLP. We have offices here in Ottawa as well as in Toronto and Vancouver. And actually we're the ones that started this lawsuit, this particular lawsuit, all of these 3-4 years ago now in Toronto. And excited to see it come to this level today.
So if I could impose on our new arrivals, the 3 lawyers who walked into this fishbowl, to start a joke. So tell us about the genesis of this suit. So why did Mr. Heller decide to go and sue Uber in Ontario?
Well, let me start that, and it's a story that I've told a couple people but never told it really in public. This issue arose when Uber changed the terms of its contract, how it pays its drivers, and it essentially made drivers accept on their phone those changes. And Mr. Heller and many of his colleagues were very upset at that, and Mr. Heller organized a bit of a protest in Toronto, and that protest got some media attention. And I was asked by Global Television to provide some commentary on that protest and whether I think that the Uber drivers, Mr. Heller and his colleagues, had a right to be upset. And I remember getting this email from Global. I was in my kitchen, and on my phone I started typing an answer. I started typing actually. Unfortunately, because Mr. Heller is not an employee, he does not have recourse. And I was going to send that over to Global saying, don't bother talking to me, there's nothing I can say here. And before I hit that send button, I had a second thought, and I deleted that email, and I wrote a different email saying, well, an argument could be made that Mr. Heller is in fact an employee. And if he is an employee, then no, potentially Uber does not have a right to make these changes, and Mr. Heller may have other entitlements. And on that basis, I did my interview, and because of that, I connected with Mr. Heller, and as a result of those discussions, we decided to pursue the matter, but rather than just pursue it as an individual lawsuit, given the fact that there's many drivers, all of whom are in that same situation, we decided to pursue it as a class action. And so it all became, if I had sent that original email that I had typed out, none of us would be sitting here likely. But ultimately I felt, and still do of course, that that was the right approach, that Mr. Heller is likely or should be considered an employee, and of course that comes with an entire host of entitlements.
So if I could ask Danielle, if you wouldn't mind, so just give us a quick summary of what happened in the lower courts before we got here, so we can understand what today's hearing was really all about.
Yeah, sure. So initially, Leora and Stephen, his colleague, were in front of Justice Perel, who maybe you've heard of, and they brought, so what happened is they filed their claim, right, and then Uber brought a motion to stay the action in favor of this arbitration clause. And Justice Perel determined that a few things, but one, that this is an international agreement and an international relationship in a commercial context, which triggers the International Commercial Arbitration Act, under which he determined this arbitration agreement was enforceable. And he rejected the arguments that we ably made, Leora and Stephen, that this was an illegal contracting out of our Employment Standards Act and therefore they shouldn't be forced to arbitration. And he also rejected the argument that this was an unconscionable arrangement. So we appealed that, and that's when Michael and I got involved. And at the Court of Appeal, things went differently, which was good for us. And that court decided that actually this was an illegal contracting out of the Employment Standards Act, and primarily because the Employment Standards Act, I don't know how familiar you guys are, but the Employment Standards Act guarantees a complaint process that allows employees or workers actually to go to the Ministry of Labor to have their rights under the Employment Standards Act adjudicated. And it also leads to other enforcement mechanisms through that ministry. The alternative also under the Act is to bring a civil proceeding. So the Court of Appeal found that those rights, and in particular the right to choose between that, could not be taken away by Uber, and therefore the arbitration agreement was invalid on that basis. The Court of Appeal also found that it was unconscionable because I haven't mentioned yet, but probably you're aware that the Arbitration Clause has some really interesting provisions. One, that you have to pay basically $15,000 US to initiate the proceedings if you want to go to arbitration. And Mr. Heller earned between $20,000 and $30,000 Canadian a year before taxes and before expenses as an Uber driver. So if you do that math, that amounts to about 60 to 90% of his gross income, just in fees. And then on top of that, the Arbitration Clause required them to arbitrate in the Netherlands, under the law of the Netherlands, which he obviously doesn't really know anything about. He has a high school education and works here in Ontario. So the court found on those bases that this was an unconscionable arrangement, that basically this was a bar to him ever vindicating his rights under the contract, and therefore he shouldn't be required to arbitrate. And that was obviously appealed.
Right. So we've now explored two issues in the case, right? We have the substantive issue at the end, which is the Employment Standards Act issue of whether or not he's an employee and entitled to that. We have this barrier to access to the courts, which is the arbitration agreement that is part of the standard term. We talk about arbitration and unconscionability, but I also want to get the third issue onto the table, which is my favorite German English expression, Kompetenz. Who would like, maybe we can get someone from, let's see, the pro-Uber side of the room to tell us about what that doctrine is and why it matters in this case. Anyone want to take that? Yeah, we're cold calling now. Anthony.
Okay, well, so all competence is, it's been overblown, misunderstood. I don't know why. It's actually quite simple. It's a rule that was created in arbitration to avoid tricks by sneaky lawyers. And the rule is this: an arbitral tribunal is competent, hence the first competence, to determine its own competence, the second competence. So it's not a tick when people say competence. It's this idea that makes a point. Now the reason it was created, and this seems to be lost on many people because they don't read history books, the reason it was created is the following. Before the rule came to be, really sneaky lawyers would look to either courts or tribunals and say, it's not that we have a problem with arbitration, it's just that we think that the underlying contract is void. And so if we're right, you know, this arbitration agreement is also void. So we have to go to the court. And that's why competence, together with the separation doctrine, came about. And it was merely to protect the integrity of jurisdiction insofar as parties were, or decision makers were satisfied that there was prima facie an arbitration agreement. In other words, that if you could say, well, it's true, there seems to be this arbitration agreement. In the event that it actually is valid, I guess we should allow the arbitrators to take jurisdiction to determine if it's valid. And that would get rid of all of those lawyers who are trying to play games of, I'm just going to run to court and avoid the arbitration agreement. Now the problem, and as there are many law students in here, as you know, certainly if you've taken classes with me, is that a little bit of knowledge is a dangerous thing. If you misuse and abuse theories of law that were there for one reason, you can end up with some very unfortunate circumstances. So all competence is a tool to protect the integrity of an agreement to arbitrate. That's it.
Okay,
I'm
yes,
going to
please.
add just a
Please
little
come
bit
in.
to that,
Yes.
if I can.
Yes.
Can I call you Professor Davis?
I think we've been friends long enough that you can call me Professor Anthony.
The way I always like to explain the idea of competence is that, as Professor Anthony started, the arbitrator has to have the ability, the competence to make the decision whether or not they do have competence. So if the arbitrator makes a decision that they don't have competence, then the idea is that, well, what gave them that power in the first place? So if you don't have that authority or that competence to decide that you don't have competence, then there would be no, parties would be able to say that the parties should never been referred to arbitration because the arbitrator never had the authority in the first place to make any kind of decision. I don't know if that adds on or
fully muddied the waters well.
or deflates it more of it.
I thought I understood.
Yeah, it was clear a second ago.
Yeah, so it's it really is a question. It almost feels like there's a chicken and egg. Yes, please come in.
I think it's important to know that the Domestic Arbitration Act has two provisions which have to be reconciled. One is the provision that's already been mentioned, which says the tribunal can rule on its own jurisdiction. And there's a whole process that says that they can do that. The other one is that if a proceeding is commenced in court and somebody says, hey, wait a second, this is supposed to be arbitrated, then the court can do the same thing with respect to the same issue, which is the issue that was in this case. Both the tribunal and the court have the statutory jurisdiction to rule on the invalidity of the agreement. So the question becomes, how do you figure out whether the court does that work or it gets sent off to the tribunal? So the question is, who decides? And that's an antecedent question to who wins.
So Michael, maybe you could come in here because this is a core part of the argument that you're making, right? Which is that, well, guess what? The court should decide this. My client should not have to go to the Netherlands to get a decision, a costly decision on this.
So you're absolutely right. There's this conflict in the statute, and what the courts have done to date is to say that a court can decide the issue if it's a pure question of law, or if it's a question of mixed fact and law, whether it can do so on a superficial or cursory review of the evidentiary record. So that's sort of the prevailing law. Today, the additional feature was the significant impediment that Danielle described about actually getting an arbitrator to decide that issue. And the question really was, with all of the hurdles that were in place as a result of this arbitration provision, if the court decided that the arbitrator should decide the issue, in reality, would that actually ever happen?
And your view is that basically, on the facts as we know them here, it would be very difficult for your client and other similarly situated individuals to do that in view of the costs associated with accessing the arbitrator.
Very well put.
Can I jump in?
Yes, please.
So I'm on the pro-arbitration side. So there's a saying that everybody in this room probably knows, which is hard facts make bad law. And there's absolutely no question that this is a very, very difficult factual case. But there's a few things to bear in mind. First of all, the arbitration provision at issue here, it's not some bizarre, outlandish arbitration provision. It's one of the most popular arbitration provisions in the world. ICC rules, seated in a very arbitration-friendly jurisdiction. a governing law clause which happens to be in the arbitration agreement, but make no mistake, the governing law clause is a separate matter, just the arbitration agreement. Bare bones arbitration agreements sometimes don't say what the institution is and therefore don't have fees. Sometimes they don't say how many arbitrators, in which case the seat decides. Today I heard many, many times, and you have already heard once, that the provision requires Mr. Heller or anybody under it to go to Amsterdam. That is incorrect. That is the default under the rules that are adopted, and it is the default if the parties cannot agree. It's very likely, in many circumstances, that you can venue that anywhere, and I believe there was an offer by Uber to actually venue the arbitration in Toronto. That's an important distinction that the Court of Appeal didn't quite get between seat, legal seat, and venue, where you actually have to go to do it. The other thing that is we've skated over very quickly here is the distinction between the two acts. Whether it's the Arbitration Act that applies to this or the International Arbitration Act. The lower court found this was an international, it fall under the International Act on the assumption that it's commercial, and there's a debate about that. And so when we get to the Court of Appeal says, well, actually it doesn't really matter because the provisions are the same. The provisions actually aren't the same. Whether they have the same effect at the end of the day, probably. What you would see if you read the factum from Arbitration Place and from several other interveners is that what the Court of Appeal did is deprive itself of international jurisprudence on these very issues. It ignored the fact that Canada signed the New York Convention by which it has agreed to uphold these international imperatives. One of those imperatives is that you do flip these kinds of issues, and again, remember where I started, very hard facts, to the arbitral tribunal in the first instance. In this case, is that the right way to go? I'm an intervener. I take no position on that. Our position was, don't throw out the baby with the bathwater. And if you look around the world internationally, what you will see is provisions that have things that that particular jurisdiction doesn't like, or they're inoperable. That is the language actually in the International Act. It's not whether it's invalid, it's whether it's null and void, inoperative, or incapable of being performed. That came up a little bit today. You could do an entire day's hearing on whether that matters. Other courts around the world have done that kind of gymnastics as to whether that matters. So I just want to throw that sort of different perspective into the mix, just to make sure we have both sides of where this comes from.
So I know Michael wants to come in.
And to poke these guys on the other
for a
side.
second.
Oh, I don't need any more poking. I'm ready to go right now.
Yeah. James, because I know your factum actually talks about the international situation a fair bit. So tell us a bit about what the status is in other countries. I know you surveyed the U.S., France, a few different places.
Sure, that's the uninteresting part of our factum. So the uninteresting part of our factum is a survey of 10 or so jurisdictions around, well, we call them leading jurisdictions, and discussing how they treat employment or the arbitrability of employment disputes. And there's a good cross-section of different approaches to a very pro-arbitration approach in the United States, to jurisdictions like Germany that bar it for almost all sorts of employment disputes. And then you have in the middle some jurisdictions that draw a distinction between international and domestic contracts, employment contracts, and those would be Switzerland and France, and maybe some others off the top of my head. Those are the two that we came up with. And the whole point of including this survey in our factum was to say, look, there are a bunch of approaches here, and none of them are necessarily wrong. But what does emerge from this is that there are difficult, this is a horrible word, polycentric policy decisions to be made, and the diversity of approaches that we see in international jurisdictions leads us to conclude that perhaps this is a question best left for the legislature. And that was the point of the less interesting part of our paper.
Michael, you want to get in?
I want to pick up on the throw the baby out with the bathwater comment. That was not argued today. To suggest that is fear-mongering. There was no sense in the court today that the facts of this case would somehow spill over into the commercial context and affect that. You're absolutely right. These kinds of provisions are common. They're common between sophisticated commercial parties. The International Chamber of Commerce, which was an intervener here, put evidence into its factum, or statements into its factum, that showed, and that's where the Uber provision says that this case must be arbitrated, that the average claim in 2018 of an arbitration before that, in that process, was $131 million US. So we're not talking about disrupting those kinds of cases. We're talking about an individual Uber driver trying to enforce his entitlement, his alleged entitlement, to minimum standards protections. This is no bad facts make bad law, throw out the baby with the bathwater.
I think there's a misunderstanding what the baby is.
I'm sorry.
I'm not saying the baby is the ICC clause.
Sorry, I listened to you, and
but I think there's a miss.
Well, I listened to you say things that I said were incorrect, which I think what you said was incorrect. But I listened patiently, I waited, and now I'm going to say that is just, there is no risk of that in this case. There is no risk that this court is going to say that the kinds of principles engaged here should apply in a commercial context. Wasn't even close to being argued today. Not a risk.
Matthew wanted to come in, and we'll get some new voices in here too. Yeah.
So, I think what Michael's getting at, what I also heard from Danielle, is why the court probably took leave and why they granted leave and why they struggle with this case, because it is obviously harder in this context. Whether you consider good facts or bad facts depends on what side of the courtroom you're on. But there's no question here that this is a much more sympathetic case than a commercial arbitration. If it was commercial arbitration, there'd be no dispute over this. It would be enforced. There's no question about that. So the issue is, does Uber get to have its clause enforced in the face of arguments, and compelling arguments on the other side, that this effectively, I think one of the interveners said, this essentially grants impunity. They said if this clause is enforced and they've been granted, not their arbitration clause, they've been granted impunity. Now the reason why I think that's wrong, and this wasn't an argument I made because it didn't fall within my bailiwick, but it was an argument that came up in reply from counsel to Uber, is that there is a separate provision in the Employment Standards Act, which is a complaint procedure. And at that point, and arguments were made back and forth. I happen to think that Justice Rowe, this is just my personal opinion, but I happen to think that Justice Rowe had it right, that Uber's dispute clause, which talks about, I think, dispute controversy, or was dispute controversy, there's a third one, or claim. I think that talks about a private dispute between two parties, not a governmental regulatory intervention. I don't see how two parties by an arbitration agreement can agree that the Section 96 rights to bring a complaint to the regulatory body is somehow foreclosed. So if you have a situation where a regulatory body can step in, and in fact one of the interveners gave an example and told a story about how this process actually works. The story she told was about the complaint procedure, not a civil proceeding. So my view on this is that if you've got a process where the dispute and the wrong that is alleged here can be resolved through the public body's process, to me that's actually a more effective way of resolving it than a class action. Now, I'm a class action defense lawyer. I happen to be fairly skeptical about how much class actions actually help the class. And I think that a complaints procedure is actually much more effective for helping the kind of people that are subjected to these problematic clauses. And when we're talking about low-income worker, middle-income worker, vulnerable people, I think that the government does a much better job of that than class actions can. So I think that's the way of resolving the tension here, is that, yes, arbitration demands predictability. Companies are entitled to their predictability. But that doesn't mean impunity, because you still have a public body out there that can enforce the ESA.
So yes, you want to
I'm the one who said that.
Well, it was
I'm the one who said it, but what I wanted is I want to take it out of the facts of this case, because as an intervener, I don't care about the facts of this case. Yep. It's about mandatory arbitration provisions in consumer and quasi-consumer contracts of adhesion. And that's what I said. And I said in the context of those sorts of contracts, mandatory arbitration provisions are in effect, and perhaps intent, effectively immunization from liability for claims that are uneconomic to pursue individually. So that's why all this, I'm not an arbitrator guy, and I'm not a class action guy. So this isn't going, this is all very interesting to me, but I'll take your word for it. But it seems to me that's where the court was going to, like, let's talk about unconscionability. They seem sort of itchy to get to that in the morning, because that deals all of this fight about these arbitration provisions and commercial arbitrations and consumer arbitrations can all be dealt with by unconscionability. Because what's the unconscionable part of the bargain? It's not the consideration necessarily. The unconscionable part is the contracting away all my practical rights to a remedy, right? And because Brown asked it, and I as the intervener, I got up and I had time to think about the answer, and I said that's the unconscionable bargain here. So you just hive off that part of the contract and say, in these sorts of contracts of adhesion, consumers, quasi-consumers, small dollar amounts, that's the unconscionable bargain. And that doesn't tread on anyone's feet in the class world or the arbitration world.
Alex, want to come in? Yes.
Yeah, I'm an employment lawyer, so representing the clinic represents low and middle income employees. So we're thinking of finding an easier and simpler way for people to enforce their rights. And unconscionability, although it's really attractive, it's hard to prove in court. So for our argument, we actually looked at other jurisdictions. And in the UK, there was a misclassification case against Uber, and where Uber was actually trying to impose a choice of law clause, saying that misclassification should be judged under Dutch law. And in that case, the court actually refused to do that. They said UK law should apply, and their reasoning was the following. The worker and Uber conclude a licensing agreement that actually says that it's not an employment agreement. And in the licensing agreement, you have the arbitration clause. So if the worker alleges that there's some sort of employment contract, then that employment contract is separate from the licensing agreement, and it does not have an arbitration clause. It does not have a choice of law clause. So analogous in our situation, it wouldn't have an arbitration clause. So that's the way we were thinking of kind of going at it, more on an objective analysis rather than looking at unconscionability or any difficult factual assessments.
I just want to go back to the point about Uber or some company standing in its shoes operating with impunity. So by show of hands, who here had at some point in their lives a minimum wage type job? By show of hands. And that's pretty much everyone here. Well, what if I told you for that job, if you had any issue, any problem, maybe you didn't get paid properly for that shift last night, your only recourse is to fly to the Netherlands, pay $15,000 US, and figure out Dutch law to pursue your rights. By show of hands, who would have done that? Exactly. And that's the problem. That's where the impunity comes in. If that then allows the company, employer or otherwise, to do what it wants, because their employees, their workers, their contractors, whoever they are, cannot pursue a remedy, then we think that that is a problem. That is unconscionable. That's a bargain that would allow a company to operate with impunity. And I think that's, to me at least, the driving force behind this. You cannot leave someone without a remedy. And you can't, it's easy to hide behind principles, competence, but at the end of the day—
It's easy to hide behind principles?
Well, it's easy to say, well, we use the word arbitration, therefore, that's all it is.
But there has to be a legal principle on which all of this is governed. That's the problem. And I'm for arbitration, and I represent companies, but there has to be a principle here. And there has to be a principle. It can't just be, well, this is a complete wall, and there's got to be more of an explanation than just this isn't fair.
Well, we protect individuals, workers all the time. The Employment Standards Act is a statute designed to protect individuals and to minimize the ability to contract for whatever you want. That's the whole point of the statute. So it's not new that we protect individuals. There's various doctrines. There's unconscionability, there's duress, there's mistake, there's reasonableness. So there's a number of legal principles that protect individuals despite them agreeing to something. But at the end of the day, I don't think that we can allow, on a public policy basis, from an unconscionability analysis standpoint, we cannot allow a company operating here, employing our people, whether they're employees or contractors, to do what it wants, to deprive someone of any ability to actually enforce the bargain that they agreed to. I think that's what the real issue here is.
So I have asked Marina. I know Marina has run. She wanted to get in on this. So yes.
I think the thought escaped, but I'm gonna Somebody said the Court of Appeal didn't really make a distinction between seat and venue of arbitration. If the Court of Appeal couldn't really figure that out,
Yes.
how do you think a regular person reading that arbitration clause is actually going to understand that the formal seat of arbitration, which is legal seat, doesn't necessarily mean that it's the same venue?
By seeking legal advice.
Who's going to get legal advice and what kind of legal advice do you
Well, I
actually,
mean-
no, James, what kind of legal advice do you need? You cannot go to a regular employment lawyer because it's a conflict of law case, and we talked about that, and I'm going to pull David out of the audience. That legal advice really has to pierce the contract and look at the rules of arbitration, look at the cost structure and say, if you ever have a problem, here is what the issues are. And even if you have that information, you have no opportunity to do anything with that information but accept that bargain.
Or go to an employment standards officer.
And
File a
so,
complaint.
so I think I really have to put, and I just wanted to say, part of it is on a policy level, the mere existence of these clauses bars any recourse because people see them and it's not worth their while. So we're not saying, and I think both on behalf of Pacific and my own behalf, I've been in this area for 20 years, we're not saying arbitration on its own is bad. It's the way it's currently being used, whether to shield people from liability or to minimize that liability that really doesn't work, but the principles on which it has been based for centuries do not work really well in this new environment, which is not commercial, where there's a significant difference in bargaining power between the parties, and where receiving parties of that contract have no ability to change any of those terms. So I don't think we're at odds in terms of arbitration is bad or good. It's just, it's the way the principles have been developed don't just work anymore doesn't work anymore in where we are right now.
So David, I
Something
know
needs
you've
to
been wanting to come in for some time.
Yeah, so on behalf of the Consumer Council of Canada, we decided we'd just go big or go home. We didn't want to mess around. We're paying our own flights and taxis and so on. The way we view it is, this is a lot of fetishization, if I can use the word, of arbitration. That really the issue here is much bigger than that. What is an arbitration agreement? It's a contract. But it's actually, and we've heard in Seidel, in TELUS, in Dell about the importance of arbitration. It's sacrosanct, and you can't mess with it because the whole world will collapse. In fact, arbitration agreements were once viewed as against public policy because they took cases out of the courts, so judges wouldn't enforce them. That's how they started. They don't have a great history. So what happened was the legislature came along and said, no, these are perfectly fine. You can contract out of the courts, and you can go into a private dispute resolution mechanism. Fine. And then people come along and said, yeah, actually it works, and it can be efficient. It's usually more efficient in commercial contexts, but it's really just a contract, and it's actually a contract that was almost dead on arrival, that was then resuscitated by statute, but it doesn't rise to some level of new important points, any more so than any other rights that people have by contract. And what we're getting to in this new era of click, I agree contracts is you can deprive people of substantive rights so easily. And it's not just through arbitration. For example, you could say your damages are limited to $20. You can sue us, you can go to the Netherlands and you can pay your fee, and if you win, you get $20, no more. Or you can have no jury trials, no punitive damages, and the list goes on, and we've all seen these agreements. So we wanted the court to approach this from the standpoint of a unifying doctrine of unconscionability that wasn't just limited to the arbitration sphere, because we don't think you need a separate test for arbitration. We think that that unconscionability is the test that's flexible enough that will address all of these issues. So we proposed a test. We'll wait and see what they say. They probably ignored us. We were the last intervener. I think they were looking at their watches. But that's how we took the view. And really, we need a new approach to contracts because the entire body of contractual law comes out of the 19th and 20th century when contracts were contracts and you had solicitors and people signed and they affirmed it in a solemn way, and you had to read it and it had to be in paper. Now, of course, we all know what goes on.
Danielle.
So just to David's point, I think it might be worth for all of us to, if you're interested, to look at the actual agreements here, because this question of limited liability does come up in these agreements, and it's probably also offside the ESA, although that wasn't part of the argument for any of the courts here. There is a limitation that you can only seek damages of your previous 6 months, what you've earned from Uber, so that certainly wouldn't comply and with the ESA from our perspective, and it kind of leads into my second point, which is about this idea that you should just bring a complaint. And I think the problem here that this case wrestles with, and that as employment lawyers we're bringing this perspective to, is that in an employment context, agreements need to be clear, that they preserve your rights. And what happens here is this says all disputes must be arbitrated. And if I'm reading that as Mr. Heller, I'm not going to understand that that maybe does or doesn't include my right to bring a complaint to the Ministry of Labor. And the Ministry of Labor process is an enforcement mechanism, but it's also a dispute resolution process, and we know that for a few reasons. One is that first, you try to have a settlement with your employer through that process. Then, if you don't reach a settlement, they do an adjudication. And if you don't like that outcome, the employer or the employee can appeal that to the labor board where there's another adjudication. So this isn't just an enforcement mechanism, it's a dispute resolution mechanism. So to say that this agreement clearly doesn't exclude that is not really a fair reading in our submission. And I think the second point is that it's also an alternative under the statute to a civil proceeding. So again, doesn't that suggest that it's more than a complaint process, more than an enforcement mechanism? By choosing that process, you're saying I cannot bring a civil proceeding. And if you've ever looked at any of these forms that you filed to bring a complaint, which I have, it says you're acknowledging if I do this, I can't go to court. So that has to be wrestled with.
So, John, we haven't heard from you yet, so please, yes.
I mean, first of all, I agree with you, because I'm not actually sure Uber was stating that you can actually file an ESA claim. In fact, I would actually say if the plaintiff had filed an ESA claim, I'm sure Uber would have made the same argument. Yeah. You have to go to the arbitration first. So that's actually the first time I'm hearing that Uber would have.
Why do you say that? What do you base that on?
Well, I mean, if they're stating that if the arbitration is, I mean, that's what the provision says, right? Like the arbitration clause.
No, that's not what it says, and that's not what the law says either.
Justice Rose certainly didn't think so.
To be clear, they never forcefully argued at any stage, just to back up what John is saying, they've never submitted, really ever, in any of their papers or at any stage, that this allows you to go to the complaint process. They never said that. That's never been submitted.
We're talking about the law here, not what Uber argued.
Yeah.
Right, but I'm just saying that it's hard to say that that's allowed if that's never been put before a court to decide.
Well, the fact that it hasn't been put before the court doesn't mean it's not allowed. It means counsel made a choice of some kind. I mean, we're talking about what the law is and what it should be and what the implications are. I don't think we should be bound here by what Uber happened to argue.
And also, just on the point about...
Sorry, except that it's Uber's agreement. They drafted it.
But on the point about what Mr. Heller would or would not understand from the agreement, I expect there are a lot of terms that Mr. Heller might or might not have understood without the assistance of counsel. And I meant competent counsel, of course. I mean counsel that knows, that wasn't meant to be a slight on anyone, counsel that knows about this area of law, okay? And
hour is probably $500.
I'm cheap.
For an Uber
No,
driver to get that legal advice.
I'm less than half that. But
salary, right? So
yeah.
What's that email address?
No. But to the point about Uber making that argument that, as a matter of fact, Mr. Heller, you also can't entertain an administrative complaint before the Ministry of Labor. Well, if Mr. Heller sought that counsel would read the stay provision in either of the potentially applicable arbitration acts, and we can have a whole discussion about that, and realize very quickly, as Professor Damses teaches his ICA students, when you look at these provisions in the model law, who is it speaking to? These provisions speak to the court. They say, court, when somebody brings an action in your court, and there's an arbitration clause that is otherwise valid and enforceable, you refer them to arbitration. This is not speaking to the Ministry of Labor, and the Ministry of Labor couldn't care what was in this contract. I mean, come on, that's not even straight-faced.
So, given where we are on the time, I want to ask everyone a question to just spur some discussion and open it up to your questions and comments as well. And the question I have is, okay, so we've gone through what's now a 4-year process of litigation. We're going to get some kind of answer from the Supreme Court when they decide it is time to release the reasons in this case. But a lot of what we're talking about really is, we're talking about some core public policy issues that are in dispute. So the question is, are these issues better dealt with by the legislature? And regardless of whether or not normatively you think it's an issue for the legislature or not, do we need legislation to clarify the status of workers in the gig economy who are facing contracts on a take it or leave it basis from major platforms? And so we can think about that in terms of Uber drivers, we can think about that as Airbnb hosts, or other significant economic relations that are being affected by large multinational platforms that operate under standard terms. I'm just curious for some views on that point.
I mean, I think absolutely legislation is needed in this area, and the uncertainty expressed not just among us here today, but frankly from the court, shows that that kind of guidance would be important. I mean, 17 odd years ago, I was counsel on one of my first cases, Canis and Rogers, where we managed to get a class action tossed out on an arbitration clause in a consumer case. And the next year, the Ontario legislature came along and essentially overruled that decision and amended the CPA, the Consumer Protection Act, put in Section 7 and 8 and said, you cannot do that. That is a prototypical kind of thing that the legislature should do. And if the legislature is compelled by the kind of arguments that my friends have been making, and they make very good arguments, then that's exactly the kind of thing the legislature should do. If people of Ontario don't like that, then they can go find a legislature that will. So I think that is exactly the kind of thing, and you know, our submissions were about certainty and the importance of arbitration to commercial certainty. You know, as a business, you just want to know what the rules of the game are. And if the rules of the game are, you can't do this, great, you know, we'll adjust accordingly. So I'm almost agnostic as to what the rules should be. I just think they should be clear and predictable and have some certainty to them. And if the people of Ontario and their legislature decides that this kind of thing should be outlawed as the plaintiffs are arguing, all well and good. I think that's the exact place it should be resolved.
Yeah, and I completely agree. And I think we're setting up this real stark pro-arbitration, anti-arbitration dichotomy. I don't consider myself to be pro-arbitration. I'm pro-respect for arbitration in as much as I'm pro-respect for the law generally. But I'm also kind of, I don't know if I'm ambivalent actually with respect to how this should be dealt with by the legislature. I really do see the merits of both sides, and maybe legislation is required. And if legislation is enacted that says, no, this category of person, and this is frankly front and center in front of the court in Wellman as well, this category of person doesn't get to go to arbitration, or arbitration clauses are unenforceable, or only enforceable after a dispute arises on their consent, as is the case in France for certain employees. That's fine too. And I don't think that there's anything good or bad or otherwise about that. Those are policy decisions. But those are decisions that ought to be made through a legislative process. And a lot of the arguments that were made today probably would have been better suited as evidence before committees, before parliamentary committees or legislative committees.
Anthony, then Wes.
Yeah, I agree, and this was an argument that I made on behalf of CFIB in TELUS. And just listening to what everyone has been saying today, look at how they characterize the party. They're referring to everyone, or not even just a party, everyone who could be a user, as persons. Well, Bill Gates is a person. He sure as hell doesn't need the Supreme Court to protect him. In other words, persons can be sophisticated, they can be unsophisticated, they can be consumers. My friend, you referred, and I remember hearing it in court, you said quasi-consumer, and I thought, well, what is a quasi-consumer? I know what you mean. Basically, someone who isn't really a consumer, maybe is a micro business player, but we don't have legislation for that. Right now, we have this, you're a consumer or you're not a consumer. And in TELUS, we made the point to say that doesn't help people. And what's difficult is a court can't, in one decision, give us a definition of a quasi-consumer. Because what does that mean? Does that mean a sole proprietor who makes $500 a week? Well, there are sole proprietors who probably make $500 a minute. Are they a quasi-consumer? What about a larger corporation or a larger company of 10 or 15 who really don't make that much, but they're running a coffee shop or whatever else you have? So that's why for a court to have some blanket, I don't think it's appropriate. So the legislator instead could carefully study the market, as Australia has done, and reach a conclusion and say, if you are this kind of person, we will treat you as a consumer. And that is a much easier way to resolve a lot of these problems, because we're using this term person like it applies to everyone.
Okay, we got a lot of hands up. So Wes, then have Michael, and then there's someone on this side too. Oh yes, here, David, and then Craig will come to you.
Okay, so let's not forget about unconscionability, guys. That was the fun part of the case. And this gets dragged back into, we've got the ESA here, which is interesting, but doesn't help the people in Wellman. It doesn't help the people in Seidel. And in Wellman, you know, Moldaver said, we're not going to do strained statutory interpretation to get you to
Just
the
tell us
end.
about Wellman very quickly.
Oh, Wellman was a class action out of Ontario against TELUS, and there were consumers. Consumers is defined in the Act, and non-consumers, and it was whether the non-consumers could proceed under the claim or not, because under the legislation, these arbitration provisions are not enforceable against consumers, so they tried to sort of hive on and piggyback, and the court said no, and Moldaver said this should be dealt with through unconscionability. So that's there, and getting too hung up on the fact that there's the ESA here loses sight of the bigger picture the court has to look to, which is to say there's all sorts of potential claims and class actions and arbitration provisions in these consumer and quasi-consumer, whatever that may mean, cases, and we need to concern ourselves with those too. And the fact that arbitration exists doesn't mean that that tool's been put away in the tool shed and the door's been locked. And I'm also hearing from the, you know, people who worry about this saying, well, you know, people want certainty, they want to know, but is it exploitation in the name of certainty? Do we wait for our legislatures that are too busy doing other silly things? I mean, let's be realistic about how legislatures work. They don't jump to the pump every time they see an issue that they got to deal with. They have priorities, and that's a feature of the common law. Is it doesn't sit around waiting for the legislature to act. Unconscionability is there. It's been there for a really long time, and it's an answer to a lot of that. And it may mean that some businesses don't know if their clause is going to be enforced. Yeah, that's life. That's reality.
Michael.
So I know it's always dangerous to assume facts, but I think we can assume that Bill Gates is not an Uber driver. Mr. Heller is an Uber driver. He drives 40 to 60 hours per week, and he makes $21,000 to $31,000 a year. So that's the individual whose fate or whose case was being decided today by the court. In terms of arbitration, I do arbitration almost every week, and I have for many, many years. I've never seen an arbitration provision like this that actually affects people as opposed to corporations. And we're dealing with people here, not corporations. In terms of whether the legislature needs to step in, our submission today was that the Employment Standards Act has addressed the issue. That what we asked the court to do was not to engage in policy making, but to give effect to the legislation. Now, I appreciate that only addresses an employment context, and I agree, though, that if you want to go beyond that, and many of these kinds of provisions will go beyond that, then unconscionability also has all the tools the court needs to address what's appropriate here.
David.
Yeah, I was going to say, and I'm sorry, I didn't get
Wes.
Wes, right? I'm sorry. Yes, what Wes said is exactly what I was going to say. He said it much better. What we need is a robust unconscionability test that you know, it takes unconscionability away from its roots, which is, you know, that contracts are certain. Contracts reflect the meanings of the mind. Contracts are bargains. All of this stuff is, let's face it, it's a bit antiquated in this day and age. And that's why the unconscionability test right now is a test that's almost impossible to meet. According to at least one version of the test, you need to show that the other side intentionally took advantage of you. Well, intentionally took advantage of you. There was nobody in the room today who could say what that means, how you'd prove it, let alone how you'd prove it in a preliminary sort of test as to whether or not something is enforceable. So we say take out that element of intentionality, and that way we don't get into legal fictions like arguably the Ontario Court of Appeal did, which is where they said, yeah, we think that Uber was intentionally taking advantage of Mr. Heller. Well, no, they were just taking the liberties that were available to them when you can write your own agreement, make it as long and as absurd as you want, and then say to the person, click here, and give them a way to skip to the bottom. That's the world we live in. So what we need and what we may or may not see is potentially an unconscionability test that addresses that. In the United States, it doesn't exist. There is no such thing virtually as unconscionability.
So, okay, I have Craig, Andrew, and Alex. You three are going to get the last words. Keep your interventions snappy, and then I do want to open it up to the floor.
Quick one. California just passed legislation to make Uber drivers subject to their employment legislation, so they did knee-jerk react after issues arose. Just on the baby in the bathwater, the baby I was referring to is the commitment to arbitrate, the bare commitment to arbitrate. I think that there are definitely issues, particularly when I talk about hard facts. I talk about a situation like this where that provision in these circumstances, I'd be very not surprised to hear a court say that they're unconscionable. It's very onerous. ICC provisions have a lot of administration and they're very expensive. But to say that your remedy is an arbitration, a bare arbitration, and this was asked, I believe one of the justices asked today about, well, how would you feel if it was just, it was in Toronto and it was, the rules weren't there so the fees weren't there, or Uber agreed to pay the fees. Is that still unconscionable in these circumstances? And that's a very tricky question. And then the last point is on mandatory arbitration provisions. You know, I think that's a very live and difficult issue because all of the things that we heard today and that you've heard today are true. And companies are misusing them and they shouldn't be allowed to get away with that. And that is not the genesis of arbitration. And I'll just go back to one thing that I said, which I think is very important. There is a big difference between domestic and international, and particularly even in this world of click-through, we're often cross-border, and we have to be careful about which courts you might end up in front of if you don't have recourse to arbitration, which can be neutral. The last thing that it's just a bit of a grenade, perhaps, is the idea that the choice of law provision would automatically result in no determination by an arbitrator. By the way, the arbitrator doesn't have to be Dutch. The arbitrator can be from anywhere in the world. It could be from Ontario. That the arbitrator, with pleadings in front of him or her, could not make a determination as to whether or not Mr. Heller is an employee or not. That's an open question. And I've been in many proceedings around the world where there's nobody in the room who's actually qualified in the law that is the governing law of the substantive issues. So just stepping away out of the domestic world, we have to bear in mind that Canada is a leader in this field, and what our Supreme Court says in this situation is it's important, and that's why you've seen 17 interveners from both sides of the table. It's not that the arbitration people are saying, well, screw Mr. Heller, this is how it should be. That's not at all, and in fact, our submissions were exactly not. It was saying to the court, if you don't like part of this provision, then sever it. But the commitment to arbitrate, the message that you could send to the rest of the world is very, very damaging for the commercial parties in a situation that's not commercial, but that's not how the impact will be when it flows down the road.
Okay, this may be a case about Uber. I'm going to ask you though, to keep your intervention to a tweet length. If we can mix that.
140 characters?
Oh,
or
280. You have two.
Okay. It's been so long I can hardly remember what I was going to say. There are three things that I wanted to mention. This will not be 280 characters. In fact, I'm past that already. The genesis of this, I want to pick up on that point that you mentioned just a minute ago, Craig, which is the domestic arbitration statute is not only commercial, it's broader. And the problem is that companies looked at it and said, look, here's a way I can manage my risk. I can limit my liability in the way that I do a whole lot of other kinds of terms in contracts. And the legislature never turned its mind to the idea in 1991 when the Domestic Act was passed that somehow people would do that and that this would be a contract of adhesion. And let alone that you could click and that would be it. So to answer the question, do we need legislative intervention? Yeah, we sure do. The next point is that this issue is the same issue that is happening in all sorts of other things that we all should be worried about. every time you go onto a website, you are either asked to or you are automatically bound by, supposedly bound by the terms and conditions of that website. Of course, nobody ever here ever goes to websites. Every time you update your phone, you are somehow asked to agree to all of this stuff. And it's not just arbitration, it's a whole lot of things. So that much bigger picture is also huge, and it's your privacy, and it's a whole lot of other things that are going on as well. The last thing is you need to pay attention to the actual arbitration clauses. This ICC is very, very common to choose the ICC rules in a commercial agreement, much less common in a mass consumer strategy. I say strategy advisedly. But look specifically at the TELUS clause that was involved in Seidel, for instance, and that they are using. They say you can arbitrate in the province in which you reside. So that's an example of how you can draft these things in a more reasonable way, and you can argue whether this should be enforced or not. If you live in northern BC and you have to go down to Vancouver, you can argue about that. The point is, there are reasonable arbitration clauses even in a mass consumer or a click-only situation that are, in some respects, much harder than this case. This case is, in some respects, a really easy one for the reasons that you say. I mean, how can it possibly be fair or right that somebody has to go across the ocean to enforce a $500 claim? That can't be right, can it?
Okay, Alex, I'm going to give you the very, very quick last word for open it up because we do have a hard stop at 5:30. So there's another.
I just wanted to mention what
Yes.
Craig briefly mentioned, that
Yes.
indeed in California, gig economy
Yeah.
workers were legislated to be employees, and maybe that's something that we should consider doing in Ontario to give people certainty.
Great. Okay, open up to questions. Please ask a question with a question mark at the end and make it a sentence, please. No big wind-up because we're short on time. Sir.
Yeah, I did that for Abiodun, LLM, IT and technology. I've been hearing the words conscionability test and then arbitration. What exactly were the issues for determination at the Supreme Court? I'm a bit lost. I just want to understand what the issues, I mean, the issue at the Supreme Court, is it about conscionability or about arbitration?
So maybe I will give that to Michael or his team to answer since you are one of the parties.
Sure. Okay, so it was both, right? There's sort of three questions, right? And the threshold question, which is what we've been wrestling about, is when can a court decide if an arbitration agreement is enforceable? And when is an arbitration agreement not enforceable is the second question. And so, you know, this question of competence is what the court first had to decide. Is it allowed to even make this determination about the arbitration agreement, or should it go to an arbitrator and the arbitrator will decide, right? So that's the first one. So, and then the second piece was, if the court can decide, is this a valid arbitration agreement? And is it invalid because it contracts out of the Employment Standards Act or because it's unconscionable? Does that make sense?
We're gonna give everyone a chance. Yes, sir. Here.
I actually had a conversation with an Uber driver last Friday, and we got talking about this case because I mentioned that I was going to go watch it, and I explained to him some of the facts and what was at stake, and then at the end of it I asked him, do you feel like you're being taken advantage of? And he responded with, well, I needed a job, and Uber seemed easy. He did the whole thing. He skipped to the bottom and he clicked. And I believe you're the one who said that in cases like this, it's not corporation versus corporation, it's corporation versus individuals. And there's a distinct lack of bargaining power on one side. So if the whole point is to respect arbitration, and what arbitration is consent between two parties to settle outside of court, to how much does that actual consent from the Uber driver, how much value does that consent have if it's just, I needed a job, I skipped to the bottom, here's what I did, and I felt safe doing so.
You're looking at me, so
I'm looking at everybody.
Well, the Supreme Court of Canada answered that, and that's how it stands right now, that mandatory provisions give consent. So, but as I said a moment ago, mandatory, that's the world that we live in with these mandatory provisions, whether they're, and as was observed, they're not just arbitration provisions, they can be all sorts of different things that people click through out of necessity. That's a world of questions that are unanswered. But the concern that's brought the people to intervene on this is that the manner in which the Court of Appeal addressed the concerns in this case potentially sends a message outside of Canada that could be very damaging to commercial parties that are not involved in this circumstance. So it's a very difficult situation.
Stefan, did you have a question? Yeah.
I have many questions. Not the least of which being, how can you consent to something you don't even know is in there? But anyway, back to basics maybe. So my biggest question, I guess, is for those people who defended the possibility of going and using the government complaints process, can you really say that there is no difference between that and the possibility of bringing your own claim before self-court? Is it really fair to say that it's the same thing, that I at least have some kind of recourse that mitigates the concerns that the other party affects, the other side of this issue affects?
I'm not sure. I'm sorry. What was the question? I missed the question.
So the question is this: you're saying that you can, like, particularly, I mean, you can object more to your perspective on this issue, as James. But I mean, the question I guess I want to throw at you is, how can you say that the government complaints process mitigates the concerns that the other people have raised? Is that not basically the same as a
I don't think I said that. I simply said that it's available in the face of an arbitration clause. That's all I was saying.
And so your position is because it's available, then that.
Well, it's available, and it's. I'm not sure I'm getting what you're driving at here.
Well, there's a sort of normative claim being made that it's unfair, right? And in part to respond to that, I think you're saying, well, they can at least possibly bring this complaints process forward.
No, that's not what I'm saying at all. I think unconscionability is a perfectly suitable doctrine for dealing with unfair contract clauses or contracts in general, arbitration or otherwise. My point about the complaints process was simply that. That process is there. The legislature saw fit to put that process there, for better or for worse. And that process remains available regardless of how onerous an arbitration clause one finds in a contract. That was really the sum total of the point I made.
I mean, I was the one who defended the dispute process, and in respect, I think you're a little naive in how class actions work.
I mean, I've been on the side of class actions and sort of like defended them, so I mean, understand your perspective on that.
Maybe you should be down here.
I don't think you're naive. There was a hand at the back, I thought. Yep. Sorry, go ahead.
What is the true test of unconscionability? I have a situation I'm dealing with. If I have a plan with a telecoms company and data is capped at X gigabyte, and then my data runs out before my next billing cycle, and then the telco decides to give me data at a rate determined by them, higher than the rate on my plan, and they're asking me to pay X amount. Is that unconscionable? Because I'm wondering, why force me to take data at your rate?
Okay, I think Wes has an answer.
I can answer the first question. I can't help you out with your phone, dude. So. But the question is, what's the test for unconscionability? And the answer is, in BC, there's essentially a two-part test, which is inequality of bargaining power and grossly unfair bargain. And in Ontario, there's a four-part test, which is inequality of bargaining power, lack of legal advice or appropriate advice. There's a list, but essentially some sort of disability in the weaker party that I guess would almost vitiate consent, I'm not sure. And then the fourth part of the test is the stronger party knowingly taking advantage of the weaker party. So there's myself and some others were arguing about what is the test for unconscionability, and the four-part test doesn't work, or certainly doesn't work in these consumer contracts of adhesion, because the stronger party never knows anything about the weaker party, so they can never knowingly take advantage of the weaker party, because the weaker party is on their phone an IP address, right? So to answer your question is, I'll tell you what the test for unconscionability is when the court tells us in this case.
And we will see. So I think we have time for perhaps one last question before we need to wrap, in view of the gathering crowd outside. Well, if not, maybe we could just wrap up with your sense of, each of you, how it went today, and where do you think the court's going to land? Let's take your bets and see where we end up in a few months. So just go start with you.
No comment.
No comment. As the cameras are rolling.
It was an enjoyable day.
It was fun.
Yeah.
No predictions.
I'll make a prediction.
It's very difficult.
Heller's going to win, and hopefully for my friends who are big on arbitration, he wins in such a way that doesn't botch up what they do.
And that would be totally fine.
You're
That'd be
used to that.
totally fine.
Absolutely.
Thank you.